I am Logan Maddox, and this is my presentation on the Tinker versus Des Moines Independent Community School District case. Before we dive into the case, it's important to put it into the proper historical context. It's set in December 1965. The United States are locked in the infancy of a war with Vietnam. Many citizens disagree with the war itself and are unsure of its motives, and this criticism trickles over into America's heartland. A group of students and adults hold a meeting to discuss how they should publicly state their objections to the ongoing war in Vietnam. Those in attendance agreed to wear black armbands during the holiday season and to fast on December 16th and New Year's Day. 2 high school students and 1 middle school student would join in the protest as well. The principals of the school district in Des Moines heard of the plan, and 2 days before the protest adopted a policy to suspend any students that wore those armbands to school and wouldn't remove them. Those students included Mary Beth Tinker, a 13-year-old middle school student, and Christopher Eckert, a 16-year-old high school, as they wore black armbands to school on December 16th, and Mary Beth's brother John, a 15-year-old high school student, wore one the following day. Each student was sent home and suspended from school until they agreed to attend school without those armbands. They didn't return to school until after the protest's original date ended following New Year's Day. The students felt that their First Amendment rights were being infringed upon as they were punished for a passive protest that caused no disruption in the school district. The main question centered around the case was, do students have a right to free speech or symbolic speech during school hours? Again, the students were trying to preserve their First Amendment rights, trying to say they had those First Amendment rights while at school, whereas the school district was trying to say that the policy was adopted to try to stymie off any disruption that would have come from it. The case originated in the U.S. District Court for the Southern District of Iowa. There, the district court dismissed the complaint and upheld the constitutionality of the school authorities' actions on the ground that it was reasonable in order to prevent disturbance of school discipline. From there, the plaintiffs appealed, and the case was sent to the Court of Appeals for the Eighth Circuit. There, the case was considered en banc and affirmed without opinion as it was equally divided. Then, the Supreme Court granted certiorari and heard the case. When it came to the Supreme Court, they reversed the district and circuit court rulings, voting 7-2 that the school district did infringe upon the students' First Amendment rights and that students do have a right to free speech and symbolic speech at school. The court ruled that armbands are the same as pure speech, which is given First Amendment protection. Furthermore, there was no solid evidence that wearing armbands was going to create a significant distraction or disruption during school hours. Since students were seen wearing the Iron Cross, a symbol of Nazism, and the school didn't prohibit the wearing of it or other symbols of political or controversial significance, the suspension of the students was viewed as a first-hand violation of freedom of speech and expression. Judge Fortas, who gave the majority opinion, stated that students do not shed their constitutional rights to freedom of speech or expression at the schoolhouse gate, and that our Constitution does not permit officials of the state to deny their form of expression. Moving over to the concurring opinions, Justice Stewart and Justice White concurred with the court's ruling. Starting on the right with Justice Stewart, he disagreed with the court's assumption that the First Amendment rights of students and children and those of teachers and adults are the same, whereas Justice White disagreed with the court's distinction of communication methods, meaning communicating with words or communicating by acts or conduct. Then looking at the dissenting opinions, there were 2 dissenting opinions. Justice Black, it was long considered a First Amendment absolutist, but he just didn't believe that children have the same rights to First Amendment protection as adults. He disagreed that the student's conduct was protected as pure speech, and he believed that the court should leave alone the reasonability of school rules. He disagreed with the test of when students could speak out in schools, and basically he said that the ruling will only benefit the loudest mouths rather than the smartest or most thoughtful students. And finally, Justice John Harlan also dissented, stating that school officials should have authority to maintain order unless their actions can be proven to stem from a motivation other than a legitimate school interest.